Yeah, thank you, Srinageshwar sir, for that presentation. In fact, quickly one or two questions.
Yes.
I think there are a lot of changes with respect to contract labor because the threshold limit is getting increased to 50, and it specifically the code says the regular employees of the contractor will
Yeah.
not be considered as contract labor.
Correct.
And I think the definition of core activity is incorporated, and
Yeah.
there is a prohibition for engagement of contract labor on
Yeah.
core activities. So
Yes.
maybe what is your opinion how this will work out?
Actually, it is a welcome change. In my
Yeah.
opinion, it is a welcome change.
Okay.
Number one. Number two is it removes the ambiguity with regard to the engagement of contract labor, because every time there is a strike by the workmen, they will immediately jump into a bandwagon to say that contract labor also has to be stopped. For example, they may stop the canteen saying that canteen workers are not to be contract labor. So these ambiguities are removed. But how it is going to result in the cost is something to be seen. I very distinctly remember way back, I understand in Andhra there was a cost benefit analysis done on the engagement of on change of this particular provision in their Contract Labor Act, including the definition of core activity.
Okay.
When that audit was done, I think I have a report of that. I happened to chance upon that report. It concludes the cost of this of the employer has gone up.
Okay.
The employer has gone up. Now, but nobody is able to throw a very clear light on this as to how it is used. There is a mixed reaction. Some people welcome it, some people have not welcomed it. So it is to be seen how it is going to work out in favor of or against the employer. But certainly there is a welcome departure from what it was earlier. But what I'm quite worried about is this coupled with the Industrial Disputes Act, whether that is going to lead to unionization of a contract labor. That is what I'm quite worried about. Let us see how it turns out.
Okay. So that possibility is there, right?
Yeah, even today there are contract labor unions, but whether it is going to give a fillip to this is something that we need to see.
Okay. So what do you think about the idea of a common registration instead of doing registration under Factories Act, registration under Contract Labor Act, registration under Dock Workers Act? Now I think common registration is being brought in. Maybe not only for this code, for other codes also. So what is your how this will work out again?
For this code, but let me tell you, every establishment is to be registered because 10 or more is for the establishment. That definition of the establishment 10 or more. For the factory it is 20, 40 comes, but that comes to with reference to operating the factory.
Okay.
When it comes to contract labor, it is 50.
Okay.
So there are three threshold elements. So when it comes to registration of establishment, the code is very clear. Every establishment is to be registered, which means 10 or more, it has to be registered. And single registration is quite welcome.
Okay. Right. Okay. But one point here is, I think these consolidation is happening only in the central sphere, central legislations, right? But still we have registration under Shops and Establishments Act. Do you think that will also get clubbed maybe on a later date?
No, I don't think it will get clubbed here. It will remain. Okay. In fact, in some of the, for example, in Tamil Nadu, there is no registration at all. For a shop and establishment. In many of the states, they have this registration. So I don't think that will remain as it is.
Okay. One last question, maybe a pretty long question. Let me just read it out. We are employing contract workers in one of our plans in the range of 200 to 250 per day for packaging, labeling and sorting activities of finished goods, which is continuous job work for them. Can these activities be termed as core activity? According to Chapter 11, Rule 57 of the Occupational Safety Code, the contract labor is prohibited in core manufacturing activity. Core activity is defined in Section 2P. However, there is proviso clause for engagement of contract labor if the normal functioning of the establishment is such that the activity is ordinarily done through a contractor only. How will you interpret this proviso in connection with the definition of Section 2P and whether we can take the benefit under the said proviso? It's a question from the participant.
Yeah, good point. The child is just born. You want me to name it? Well, if it is not a core activity, then there's not a problem. But if it is going to be a core activity, and if it can be done, if it is going to be done only by the contractor so far, there is every possibility that the inspector might look at it differently.
Yeah.
Because
But I think the querist seems to be raising a point that there is a kind of contravention, right? If this work is normally done through a contractor, then that should be allowed.
but is it the main activity of the company?
Yeah, I'm not very sure because this is there in the Q&A box. That is what I'm just reading out.
It is going to be the main activity of the company. The inspector will take a different view. But if it is not, like in many other manufacturing company, you produce something that gets packed and sent off, then there is not a problem at all. That is
Okay.
not a problem at all. Though it is not very clearly given here, as packing here. Loading, unloading, running of hospital, courier services, civil and other construction, maintenance, gardening and maintenance, housekeeping, laundry, transport services, ambulance services, any activity of intermittent nature. So somebody needs to say whether it is intermittent or not. But packing, whether it is going to be seen as the packing is traditionally done by the contract labor in many of the companies.
What is
So,
mentioned is packaging, labeling, and sorting of activities.
yeah, so we might take umbrage into the exemption given in the 57.
Okay, maybe this needs to be studied further, right?
Because we studied further, is going to be certainly a point. So that is the reason, see, putting such definition in a slightly watertight compartment will always give rise to some kind of ambiguity. But having no definition also gives rise to a lot of ambiguity. So I think the former is better than the later.
Okay, fine, sir. Thank you so much once again for your presentation. And we'll move on to next speaker, who will be Ms. Veena Gopala Krishnan. She's an employment law partner at AZB and Partners, and she's based out of Bangalore. She focuses on providing strategic and practical counsel to employers across industries on a wide range of issues pertaining to Indian employment law, keeping in mind rapidly evolving work dynamics. A significant portion of the practice is focused on assisting employers mitigate risk of litigation and ensuring compliance with Indian laws. She regularly advises clients on complex employment law issues pertaining to workforce structuring, senior managerial exits, reductions in force, closures, employee transfers, integrations pursuant to corporate transactions, and cross-border employee benefits. And over the last few months, she has extensively advised clients on employment law issues linked with COVID-19 pandemic and assisted them in keeping pace with the rapidly evolving regulations and restrictions. And Veena has been chosen as the exclusive winner of the Client Choice Award presented by International Law Office in partnership with Lexology for the employment and benefits category for India for both 2019 and 2020. And she was also conferred with Women Super Achiever Award in February 2017 by the World HRD Congress, a forum for human resource professionals. Once again, we are extremely happy to welcome you, Veena. Now it's over to you, and she will be touching upon code on social security. Yes, it's all yours, Veena.
Thank you so much, Varadhan, for the very generous introduction. And I must really thank all the attendees for staying on and being very patient with all of us while we take our time to explain the various codes. Thank you so much. It's I think we are beyond, we're half an hour beyond our scheduled time, but I can see the numbers are very, very stable. So thanks again for your time. I'm going to be very quick with the overview on the code on social security. So there is time for Q&A for all the other panelists as well. And to start off, Faisal, can we have the first slide? Next. Yeah. So yes, a very quick snapshot. The four codes, including the code on social, the three codes. Sorry, one was already passed and is law. The Code on Social Security was introduced in the Lok Sabha on September 19th, 2020. That's last week. Day before yesterday, it was passed by the Lok Sabha. Yesterday, it was passed by the Rajya Sabha. And today, we have Aparajita setting up this webinar to chat about the code. So we've been really proactive in reviewing the code, so all our attendees and audience can benefit from it. Now, what is the objective of the code? The objective is to amend and consolidate the laws relating to Social Security with a goal to extend Social Security to all employees and workers, be it in the organized and unorganized or unorganized sector. And this has been actually a part of the current government's election manifesto since 2014. So it's something that they've proactively worked on. Faisal, can we move to the next slide? Now, while I talk about consolidation, unfortunately, I think this code on Social Security is also a code of missed opportunities when it comes to a proper job of consolidation. What they've really done is a compilation of 9 legislations. It is pretty much taking each bare act and stacking it one on top of the other. That is what it seems like to me. There have been some beneficial changes, but there could have been so much more. There were previously about 250 sections in all of these legislations. That's been compiled into 164. There were 10 schedules amongst all of these legislations. That's been made into 7 schedules. What are the legislations that were that are subsumed under this code on Social Security? There's the Employees Compensation Act. There's the Employee State Insurance Act. There's the EPF Act, the Employment Exchanges Compulsory Notification of Vacancies Act, the Maternity Benefit Act, Payment of Gratuity Act, the Cine Workers Welfare Fund Act, Building and Other Construction Workers Act, and the Unorganized Workers Social Security Act. The next slide, please. So to be able to understand this code better, it is essential for us to understand the meaning and scope of Social Security. Social Security as a concept was not previously defined, and now the code provides a definition. And what the code really says is Social Security means the measures of protection afforded to employees, unorganized workers, gig platforms, etc., other kinds of workers, to ensure their access to healthcare, income security, especially in cases of old age, unemployment, sickness, invalidity, injury, maternity, etc. So this is, in concept, Social Security is really essential for any society to have a balanced growth. And a lot of the provisions under the Code on Social Security were already there. So what I am going to be focusing on is what has really changed and what I think is most impactful, because the code is 164 pages, I don't know how much, 150 pages long. And if we were to do a section by section or a page turn, it would take us a whole day. Next slide, Faisal.